Welcome back to Senate Judiciary. It's January 15th. I mistakenly said we'll be hearing from a professor at 10 o'clock. That was my mistake. We'll be hearing from a professor at 10:30. We have Commissioner Morrison from the Department of Public Safety here to provide the department's input on 208 and 209. I'm sorry, just 208.
Hope it's just 208.
Just 208. And I will, and the floor is all yours.
Okay, Senator, my name is Jennifer Morrison. I'm the Commissioner of the Department of Public Safety. In my background, I have 28.5 years of municipal law enforcement service, and I've worked at the Department of Public Safety for 5.5 years. In my capacity as Commissioner, I oversee the Vermont State Police. Relative to Bill S-208, there were a couple of areas that you asked me specifically to weigh in on. I wanted to make a couple of quick statements and then move to those observations plus a couple I have. I'm happy to help you clarify the exceptions to a no mask statute, but I actually think there's a better path forward to achieve the same goal. I would recommend that you either direct the Vermont Criminal Justice Council to adopt a rule as part of the existing code of conduct, or that you move in the direction of requiring a statewide policy on this topic. And I can tell you that the Law Enforcement Advisory Board has already taken this matter up as of Monday morning's meeting. They added it to the agenda, because their meeting fell right after our legislative chat on Monday mornings, and I let them know about this draft language, and they immediately took it up and they have added it to their next agenda, their next meeting's agenda. So the Law Enforcement Advisory Board is already queued up to recommend a policy, and whether you choose to require that the council make it mandatory or advisory would be up to you guys. It's a matter of what your intended goal is. The reason why I would leave it out of statute and in the realm of the council is that it brings any alleged violation into a well-established and consistent framework statewide. It can't be impacted by 14 different prosecutors having 14 different thoughts on the matter. It would come into a one statewide consistent framework for review and potential sanctions for misconduct. I also think it could be written in a way that would help you achieve your goal further, which might include broadening the culpability from just the individual officer to an immediate supervisor or the chief of the agency, the head of the agency, the CEO of the agency, if it's treated in a misconduct realm as opposed to in a criminal court realm. And obviously we don't want to do anything that would, I don't think this would become a statute that's used a lot, but you don't want to do anything to contribute to the existing court case backlog. So with that being said, I do think there's a better way to do this. If it were to remain in statute, I would recommend that you could reduce this to almost one paragraph by saying what it is you want up front, that it shall be unlawful for any law enforcement officer in Vermont in the course of their official duties to obscure their face for the purpose of hiding their identity. I mean, that's what you're really after. And I think that just saying it affirmatively leaves a lot less room for wiggle room inside exceptions. So that's my opinion, is just say what you want and make it be so. On page 1, line 12, when you reference badge numbers, I would recommend that you change that to identify themselves by name or radio or badge unique radio or badge number. Most people would argue that we don't wear badge numbers, that we have radio call numbers, and that's how you identify on the radio. And I think that there's, in some agencies, the sheriffs have the unique numbering scheme that I'm sure the senator could fill you in on, but I would recommend that we don't just use the word badge number, that unique radio or badge number. On line 2, that appears again. I'm sorry, page 2, line 13, that badge number appears again. On page 2, line 19, a law enforcement officer may wear a medical grade mask that is surgical. Unless you tease that out, that could be worn and be acceptable when its real purpose is to disguise your face. So like, again, I think you need to affirmatively say what you don't want and not bother with all these exceptions, just my opinion. I noted that there were a few things that really aren't teased out in the exceptions. You asked for input on line 7 on page 3, which is a mask designed to prevent against exposure to cold during a declared weather emergency. I don't know what a declared weather emergency is, so I think that would have to get changed. Obviously, a balaclava is a reasonable headgear if you're walking a beat in today's weather. If you're on a snowmobile, obviously underneath your helmet, you're going to have that type of gear, and you're going to probably leave it on while you're interacting with people on the trails, right? I didn't see exceptions for ATV or motorcycle face coverings for protection. Okay, bandanas, whatever it is that people wear. Search and rescue, likewise, again, inclement weather of any time. It could be of a kind. It could be hail. It could be pelting rain. And this, by way of saying all this, I'll go back to the exceptions make it more likely that you're going to get people who wear them and claim an exception that is not necessarily what you were after in drafting this bill. And then on page 3, line 11, go ahead, sir.
I got a quick one on there, Commissioner. So what your suggestion is, it's not even optional for officers on the road now. They'll want to wear a mask to protect themselves from exposure to whatever they may feel.
No, they should be able to.
They should be able to.
Yeah, 100%. They should be able to. I mean, I live with an immunocompromised person. If I were still on the road and I were going into a crowded space, I would probably be putting on a mask of some sort to protect my husband. But the way it's worded right now is it says that it is an exception to wear a medical grade mask, either a KN95 or an N95 or a surgical mask. But it doesn't say, to protect you from airborne pathogens or something like that. So again, I think we've already seen this in other parts of the country where it just becomes part of their regular gear to wear a surgical mask when the purpose is to obscure their face, not protect themselves from necessarily protect themselves from airborne pathogens. So that's, I think you should just say what you don't want. And I also don't think it should be in statute. It should be dealt with by the council. The last area that you asked me to weigh in on was on page 3, line 11, related to tactical services unit. Team officers may use gear necessary to protect their faces from physical harm while performing TSU responsibilities. You could say that this terminology is not incorrect. We happen to call our special team TSU, but tactical team, that nomenclature would be commonly understood to be any rapid entry team, the emergency response team is what they call their team up in Burlington, SWAT. Some people still use that nomenclature. I think that the way you've worded it would be easy to suss out, that people know what that means.
Okay.
So that's my feedback on it. I clearly understand what you're trying to accomplish. I think there's an easier way by doing it through the council.
Thank you. That's your testimony is really helpful. I think one of the challenges, or one of the things that I'm trying to think of or figure out now with your recommendation is, obviously part of this is also in response to the concerns about federal agents that are wearing masks, which is something that we've seen a lot more of over the last year. And can you share any input on if this were to go through the council, or the statute were to say statewide policy shall be developed, would that be able to also incidentally affect federal agents engaged in law enforcement?
No, the council has no jurisdiction over federal agents. I imagine that you would have legal experts who could advise you on whether or not a state statute can be employed against a federal agent in their official capacity. I would imagine they have something related to qualified immunity or other protections if they're in the furtherance of their official duty.
Yeah, and so that's what we're trying to suss out here and avoid doing what California did by kind of separating agencies into groups and having it apply to some agencies and not others, which was half of the reason they got sued. hence the reason we were trying to put it in statute in a, in a fully encompassing way that doesn't specifically target any one particular group of law enforcement, but law enforcement generally under the 10th Amendment. But no, you raised a lot of good and helpful points. So thank you. And Senator Troubles.
Absolutely. I am wondering if currently, and forgive me, it's been a bit since I've gone through all the language around the council, but if this were in statute and a local or state officer violated it, would that, because they violated the law, would they be able to be disciplined that way by the council?
I mean, if this were a statute, they could be charged criminally, is the way you've envisioned it.
I
But
think
if
civilly, just
civilly,
yeah.
okay. If you directed the council statutorily to create this as part of code of conduct or as policy, to consider it as misconduct, they would not be able to be charged civilly, but they would be answerable to the council for whatever level of misconduct the bucket this falls in, the category A and category B misconduct. So it would be handled administratively through and it could impact their certification or they have the ability to take other actions besides suspending or terminating.
I guess what I'm wondering is if an officer violates the law, is that grounds for potential misconduct by the council?
So if you left it in statute and there was no tethering it to the existing council regulations, yes, there are provisions, and this is an area you want to talk to Chris Burkell or their attorney, but there are, in the misconduct buckets, there are provisions for any violation of the law. So, I mean, that could be anything from a hunting and fishing violation to something like this or something else, but it being a civil violation, I think it was dealt with at the lowest rung of misconduct. That's my guess.
And would it be possible, and this might be actually a question for our attorney, who I'm not sure is in the moment. Oh, you are the right attorney. You're the attorney on this.
I am not in Maine interest at the moment.
Okay.
So I'm happy to report back.
Okay. And so I guess my question for you, or maybe the attorney, is could we do both? Could we put it in statute and explicitly allow the Criminal Justice Council to consider this misconduct? And again, if you're not the right person to ask, that's okay.
Okay, I'm not the right person to ask, but I'm quickly doing an inventory of my brain, and the end, I would guess that the answer is yes, but you would run into the same issue I stated at the beginning, which is you have 14 counties that might have different political persuasions and have different, at the end of the day, isn't the point to treat all law enforcement officers the same under the 10th Amendment? And if you have 14 different prosecutors weighing in on how to interpret that, you have the potential for inequitable treatment right off the bat. So,
Brings up a larger concern about inequitable treatment, period.
yeah, sure enough. So anyway, I understand what you're trying to accomplish with this draft language. I just think there's an easier way to do it, but that would probably gain compliance from all with no jurisdiction over our federal partners. And I'm not sure we can have a stick for them anyway.
Senator Mattis.
You talked about the council and that you had met with them on legislative day or whatever it was. I'd want to get whatever we can do, want to get it right. Don't want to just rush because of incidents that have happened recently. What kind of the process for the council for looking at that next meeting?
So the Law Enforcement Advisory Board is a separate entity from the Criminal Justice Council, but it is frequently where matters are referred to by the legislature or by the governor's office to begin drafting policy and to revise policy, receive input, etc. That is how policies related to pursuit and various other things get formed. And then they are elevated to the council. Once the LEAB says, okay, we think this is a done draft on our end, it gets handed off to the council and they have, a broader number of people on the council, and it is passed to their launch council, and then they go through the process of taking it on it and then voting to adopt it or not. So the council also has a specific subcommittee that deals with misconduct, so it would probably go from the LEAB to there and then up to the full council.
Okay, so it'll go to a lot of the stakeholders and
Yes,
really, that's how I think you get
yes,
better, not quote unquote, buy-in on a policy, right? When it goes through and people have input and.
yes. It'll be considered from many vantage points, including non-law enforcement partners who have a large number of seats on the council right now.
Okay.
So,
Again, may not be the right, you may not be the right person, but it's sort of, and that my question is, if you have a sense of the average amount of time it takes for a policy to go through that process. And you may not, and that's okay.
Well, no, I have a lot of experience with policy and with the LEAB and the council. This is not nearly as complex, controversial a policy as pursuit, use of force, and some other policies that have bubbled up through that pipeline. So I would guess that it could be done within 6 to 9 months, or I would be willing to bet that the LEAB could pass it off to the council within 6 months, and the council would have whatever process they undertake. I can't speak for them.
No, I know you can, which is
Right.
why I again want to acknowledge that this is the thing I'm doing today. I'm asking people questions that maybe they're not.
Well, it's speculative, but it's based on 35 years of experience with the system, not just with me. I appreciate that. Okay.
yeah, I think, this isn't really a question, it's a thought, I guess, but for the purposes of making this all encompassing and not creating silos of different law enforcement that are subject to different rules, going to that federal question. I'm wondering if it makes sense to have a statute that makes this essentially a traffic ticket violation, a civil violation. And having that violation apply to all the categories of law enforcement after the LEAB and the BCJC come to some sort of agreement as to how to manage the misconduct aspect of it, and also coming up with better definitions for things like the cold weather issue and some of the others that you raised earlier. Does that seem like a feasible approach?
Shooting from the hip, I'd say that what I like about what you just proposed is that it introduces a hearing officer who can be a neutral arbiter of whether or not the reason that the law enforcement officer was wearing a mask is reasonable. I think what this doesn't address, that this proposed language doesn't address, that has to be considered as reasonable, is that there are instances where law enforcement officers, whether that's local or state or federal, are identified for legitimate conduct in uniform and are doxxed and harassed, and their families suffer. So there are legitimate reasons that may not appear in here that a law enforcement officer might protect their face in certain circumstances. That might be the movement of a high profile prisoner. That might be an action of speaking on civil unrest. It could be, it could be a reason. So I think introducing someone that can weigh the totality of the circumstance and make a decision, that's appealing in that it's one, not a council of some political appointees, do you see what I'm saying? Like one person who's evaluating the circumstance. So that appeals to me from what you just mentioned, but you'd have to ask Director Brickell what would happen in the current scheme if a law enforcement officer got a ticket. I'm not sure that would rise to their level of scrutiny. I just don't know the answer to that. Merciful, I don't know the answer to that.
Understood. This has been a helpful conversation. Thank you. I think that's all I have at the moment. Maybe have anything else to say about it?
Just real quick with based off what you just said with the, having the statute kind of directing LEAB.
Law enforcement advisory board.
Yeah. Does that cause confusion about who kind of has jurisdiction over an issue or no?
That would probably also be a question for Director Brickell. What I envision is sort of, I guess, a belt and suspenders approach where you have this, the civil violation that would apply indiscriminately to any law enforcement that is violating what we have in statute. And what we would have in statute would come from the recommendations of the LEAB, the Justice Council about the better language about the exceptions, but also the misconduct process, because we can't, as a state, do any sort of misconduct process against federal agents or law enforcement. What we can against local and state. But that's what I'm thinking.
Because my thought is if you have two folks on the road speaking LEAB and then also a state's attorney, if the state's attorney is the first one to make the action, you're going to get 14 different responses. And I don't know if it causes confusion throughout the state about which way you go about handling one of these matters.
I mean, don't you have to answer the fundamental question of whether or not a Vermont statute would be applicable to a federal officer? Because if it's not going to be applicable to a federal officer, you gain nothing from it. I mean, it's a feel-good measure at that point to pass the statutes. Then you could go directly to directing the council to add it as a type of misconduct or have a mandatory policy.
So my understanding from the initial testimony that we had from Attorney Sadatny, and probably testimony that we'll have in about 10 minutes, is there are, in certain circumstances, ways that we can enforce state laws against federal agents, but it cannot be discriminatory. And also it does take it to a much more challenging level if we attempt to create a criminal charge against a federal agent. And then there's also the argument of, are we interfering with a federal investigation, which would be problematic. The two problems that California ran into is that they did discriminate. They created different processes and made them exceptions for law enforcement. They also had it as I believe they had it as a criminal charge. Thank you. And so the federal government, on my understanding, their lawsuit alleges that California statute discriminate against the federal government because they're being treated differently compared to local and state law enforcement. And the statute interferes with their investigations. So, but I guess, I think the question, at least in the courts, is unanswered at the moment as to whether or not, under the 10th Amendment, a state can pass this type of law. And yeah, and I think if you're able to stick around, I think we'll hear from the professor here soon. Mike will articulate it much better than I can.
I have to go back to headquarters. However, I would think that if you don't get that answer settled, you'll get 2/3 of what you're looking for by moving through an already established framework at the council. I just don't know the answer about whether we would have anything to coerce the choices of a federal agency doing legitimate law enforcement work in the state of Vermont. So I mean, I'll be curious what the final answer is too, and hopefully we'll know more in the next few weeks.
Okay, thank you.
Thank you for being here. Sure,
You're well.
experience.
Thank you. Appreciate it.
That's on the smoke, it's something that when we started out.
No, I don't know.
I did actually introduce it by saying it's a simple little bill, and I did that with a fair amount of tongue in cheek.
Okay, good morning, Professor. Thank you for joining us. I know we're a couple of minutes early, but you good with us just getting started now?
Hi, yeah, good morning. I thought I would get here early in case there are any technical problems, but I'm happy to start whenever you're ready.
Fantastic. Would you like to right now? Great. Yeah, thank you, Professor. Do you just want to introduce yourself, a bit of your background, and then if you want to share your general views on the bills that you were invited here to speak on, and then I suspect the committee may have some questions for you.
Great. Yeah, so good morning, everyone. Thank you, Senator, for inviting me to speak with you today. I'm Jessica Bowman-Posen. I'm the Betts Professor of Law and a co-director of the Center for Constitutional Governance at Columbia University. I've taught here since 2012. Before that, I was an attorney advisor in the United States Department of Justice's Office of Legal Counsel. And so I'm pleased to have a chance to speak with you about the two bills you sent me, 208 and 209. In brief, I believe that these bills are an important exercise of Vermont's police power, that they're not foreclosed by the Supremacy Clause of the United States Constitution. And so let me say a word about the state's affirmative power to adopt such legislation. Then I'll say a word about the most important legal challenges and responses to such challenges, and then happy to address any questions you may have for me. So as I'm sure you know, the first legal question when considering legislation is whether the government has the power to adopt a law in the first instance. With respect to that question, here the answer is undoubtedly yes, because in our constitutional system, states possess the police power. This is an inherent authority to regulate, to protect the health and safety and welfare of states' people. And nothing in the United States Constitution eliminated the state's police power, which pre-existed the Constitution itself. To the contrary, the 10th Amendment of the United States Constitution reserves such authority to the states. A minor drafting point, in fact, on that score is that I noticed that right now 208 indicates that it is the intent of the General Assembly to exercise the power granted to Vermont by the 10th Amendment. In fact, the 10th Amendment does not grant Vermont any power in this regard. Vermont already possesses the power. It simply recognizes that Vermont possesses such power. Again, it's a minor detail, but I think it speaks to the fundamental importance of the state's police power in our constitutional system. This is a power that also makes the states, as well as the federal government, responsible for ensuring the liberty and the security of the American people. And as you no doubt also know, most protections in this country therefore come from state and not from federal law. An additional small drafting point with respect to 208 and its exercise of the police power is that I would recommend including legislative findings about why, as you're probably already planning to do, but about why this bill is necessary and useful with respect to protecting the safety and welfare of Vermonters. For example, the documented instances of people impersonating law enforcement and engaging in crimes like kidnapping, ensuring that Vermonters who may be subject to arrest recognize that the person attempting to arrest them is in fact law enforcement rather than such an impersonator or the like. It's not necessary to have such findings, but I think it would bolster the understanding of the bill as important police power legislation. Now, the harder question, which I assume is mostly what I'm here to speak about, is whether even if Vermont has the authority to act in the first instance, this legislation violates a distinct provision of the Constitution. Even when states use their police power to pass legislation, they can't violate other parts of the Constitution. Here, I think the strongest legal challenges would come from the Supremacy Clause from Article 6 of the Constitution, specifically the doctrines of intergovernmental immunity and preemption, both of which are understandings that come from Article 6 that declares federal law supreme over state law. So let me say a word about each. There's much that could be said. I'll try to keep it brief again and then turn to your questions. With intergovernmental immunity, the doctrine says that states may not discriminate against the federal government or regulate it directly. In the draft bills that I am looking at, there is no such discrimination. 208 expressly applies even-handedly to all law enforcement, local, state, and federal alike. 209 likewise appears to apply to all levels of government, although I don't see an express specification of its applicability. So a drafting point here is I would urge you, however you may modify this legislation as it moves through your committee or through the legislature, not to change this aspect of the law to ensure that it continues to apply in an even-handed, neutral, and equal way to state and local as well as federal officials. That is a critical piece of defending against an intergovernmental immunity challenge. The stronger argument with respect to the bill is not about discrimination, but about direct regulation. That's the second piece of the intergovernmental immunity doctrine, that states cannot directly regulate the federal government. And here, insofar as the bills apply to federal as well as state actors, that will be a federal government challenge. Here, there are hard questions. The Supreme Court, though, has distinguished between state laws that control, in its terms, federal officers and laws that, in its terms, incidentally affect the mode of carrying out federal law. So in a seminal case from more than a century ago, Johnson versus Maryland, the court said that Maryland couldn't require federal postal officers to have a state license in order to drive and carry out their federal employment. This would amount to controlling federal officers. But the court said in the same case that federal employees don't secure a general immunity from state law, and that states can require federal officers, even when they're carrying out federal law, to comply with general rules that, again, might affect incidentally the mode of carrying out the employment. The court gave the example of a traffic ordinance regulating the mode of turning at the corners of streets. So I think here Vermont has a strong argument that 208 and 209 do not control federal actors. They don't prevent federal law enforcement or state law enforcement, but here federal law enforcement from carrying out their statutory obligations. The bills more narrowly affect the mode of how all law enforcement actors do their work, with identification, without masks or disguises except in specified contexts, not in certain sensitive locations. I think this kind of regulation is not quite as incidental as the example provided in Johnson of turning at street corners, a traffic regulation regulating that, but it still seems closer to that permissible end of the spectrum than to controlling federal officers themselves. And again, here the state's interests and the strength of the state's police power interests would also weigh in the balance. The court has instructed that in the intergovernmental immunity context, courts should consider the full range of each sovereign's legislative authority. An additional point with respect to 209 is that Vermont would be acting not only as a regulator, but also as a proprietor, defining what activity is permissible in state-owned facilities that lie at the core of its sovereignty. So that brings me to preemption, which again is a similar doctrine with respect to regulating federal and state interactions under the Supremacy Clause, but operates a little bit differently. As relevant potentially to these bills, preemption doctrine renders invalid state law that conflicts with federal law. I think the principal reason a preemption challenge to these bills should fail is that there is no conflicting federal law. There are only discretionary executive branch decisions. For 208, with respect to identification and masking, there is, at least as far as I am aware, no federal law, no federal regulation carrying the force of law that requires or that expressly permits unidentified masked law enforcement. So any conflict with the state bill would seem to come between the state bill, the state legislation on the one hand, and a discretionary executive branch decision, not federal law itself. There is a longstanding presumption against preemption in areas of traditional state regulation, including policing. And I think given this conflict that does not involve federal law itself, a preemption challenge should fail. Again, with 208, I think the intergovernmental immunity challenge would be the stronger challenge, but a preemption challenge could also be raised. I think it is a weaker challenge. For 209, the preemption challenge might look a little different. As I understand it, Vermont is seeking to add certain sensitive state locations to its existing prohibition on civil arrests around courthouses. The common law privilege against courthouse arrests long predates Congress's adoption of the Immigration and Nationality Act, the INA, and other federal immigration laws. So as a number of federal courts have already recognized, if Congress meant to abrogate that courthouse arrest privilege in these federal immigration laws, it would have had to speak clearly. It did not do so. Federal law has therefore not been understood to abrogate that privilege and to provide the kind of conflict that would lead to preemption. With respect to the extension to other sensitive state locations like schools and hospitals, there's not a comparable privilege that I am aware of. So I think the reliance would instead be on overarching federalism principles that recognize the sovereign prerogative of states to control their facilities, to control their properties. I think here again, there's a strong argument that the INA and other federal immigration laws do not expressly provide for civil immigration arrests to occur in state facilities over which the state has exercised its sovereign control. And that again, comparable to the courthouse context, given such silence, that federal law is not best read to preempt state law. I'll also note, as I'm sure you're aware, that the executive branch decision to begin to conduct enforcement in these spaces is itself a departure from past federal executive practice. I don't believe it has been codified as such in a way that would carry force of law. So again, we have a conflict principally between executive branch discretionary decisions and state law or proposed state law rather than state law itself. So maybe I'll stop there and just say again that I think although these bills would be quite likely to face legal challenges, I think Vermont has compelling arguments as to their constitutionality, and I would be happy to address any questions you might have for me.
Thank you, Professor. Senator Vohosky has a question.
I have a question, and you may not know the answer to it, but also you may. So my understanding is that Colorado had passed in 2025 a law very similar to this about creating that sensitive space. And they are actually, their law, my understanding is a prohibition on entering into hospitals or schools without a signed judicial warrant. Are you aware of this law or if it has been challenged in the courts?
I'm not aware of Colorado's. I know in New York, some of this work has been done through executive order. There's the Protect Our Courts Act that speaks again to the courthouse arrest privilege. And then so far through executive order rather than state legislation, the state has attempted to expand the protection to other sensitive state locations. And in the litigation that has been proceeding, is ongoing, but that has been proceeding this year, the district court upheld the state's policies against challenge by the federal government. I'm not familiar with the Colorado.
Okay. So I knew that it may be so specific that you might not be, but I figured it was worth asking.
Maybe any other questions? Professor, you covered a lot of the areas that I wanted to get at. But one question that I do have is regarding enforcement in terms of when and where a state can enforce a law against a federal agent, and the difference between enforcing a civil law or a civil violation versus a criminal violation. I was just wondering if you could provide some more information in that area.
Sure. So I think in this particular context, the kinds of questions one would usually have with respect to enforcing state law against federal officers ultimately get folded into the questions of intergovernmental immunity that I was addressing. But let me say a few words about supremacy clause immunity sort of more generally to respond. If the state wants to, say, prosecute or potentially bring a civil action against a federal employee, let's say that a FBI agent kidnaps a child down the street and the state wants to bring a suit and wants to bring a prosecution in that case, the state can do so. States can prosecute federal officers. Federal officers have supremacy clause immunity defenses they can raise. So what would happen in that context is that the state would bring its its case. The federal officer raising, again, in that case, it's unlikely to be a colorable defense, but raising a supremacy clause immunity defense would be able to remove the case to federal court if there's a colorable federal defense, which would be supremacy clause immunity, which is also from Article 6. At that point, a federal court looking at the state's prosecutorial authority would determine whether the federal actor was operating in the scope of his employment and whether his actions were reasonable and necessary and proper. You see some different language, but basically reasonable with respect to that. So in the example I gave, surely the answer is no, not in the scope of employment, not reasonable and necessary. In contrast, if the kidnapping charge arises from a federal agent arresting someone in the course of carrying out federal law, and the state wants to bring a prosecution, that defense would be a colorable defense. So that's, again, there's no bar on states prosecuting federal officials. The federal officials have an immunity defense, but they have to then be able to show that what they were doing was part of the scope of their employment and that their actions were reasonable. So that's, again, probably with respect to a state law that is not already specific to this context, that hasn't been upheld, for example, against an intergovernmental immunity challenge, but a general state law that applies to everybody, a state law against kidnapping, against murder, et cetera. With civil actions, I think it would be much the same if you're dealing with a violation of a state statute, if that's what you're talking about. Again, there could be a possible claim of immunity, but the courts would evaluate whether it is in fact a valid claim of immunity or not. So there's no categorical bar on states enforcing their law against federal officers. It's just the question of whether the federal officer has immunity in response.
Senator Bohosky, I think, has another question.
I do, but I'm trying to figure. So based on your testimony, we as a state have the right to, if the law is deemed okay, to impose either a civil or a criminal penalty.
I think the state has that choice if the law is a valid exercise of the state's police power, is not foreclosed by the supremacy clause because it is preempted by federal law or otherwise a direct regulation of the federal government. I think, yes, the state can make that selection. The questions with respect to immunity are challenging ones, but they're ones that could apply in either context.
And would that immunity apply if someone were, and this is going, I think, to this is more to 209 than 208, but in 209, there's some language that kind of a private right of action. So someone could sue that federal agent if they violate this. Would that immunity clause apply to that as well, or only to the state's actions?
Yeah, I mean, I think, again, with respect to this kind of legislation, you are almost certainly going to, if you pass it into law, get a challenge by the federal government that would be a facial challenge, just challenging the law full stop. That's why I think the enforcement questions become a little bit more complicated, because either a court might deem the laws unconstitutional, in which case you won't get to that point. But if a court upholds the legislation against a challenge under the supremacy clause, then it should be much harder for a federal officer in either context, civil or criminal, or with respect to the private suits you're suggesting, to raise a colorable defense. It's possible, again, there could be some kind of exceptional circumstance that was not contemplated. But I think most of these questions would be folded into the intergovernmental immunity analysis that would occur with respect to the facial challenge to the legislation.
Okay. Thank you.
Any other, Senator Mouse?
Just I won't say a quick one because I don't know if it'll be quick, but thank you, Professor. You spoke about the state's people. What's the definition of the state's people? Because when I look at, the prohibition in the bill, a person shall not be subject to a civil arrest. And I kind of put that towards the state's people. So what's the definition of the state's people? Somebody passing through, a resident, kind of what's that definition?
So I don't think there's a single definition for constitutional purposes, but I would say, generally speaking, when we talk about the state's people, we're talking about residents of the state.
Is it like a full-time year-round resident, or? what would be the definition of a resident of the state?
For purposes of the bill, is that what, is that?
Yeah. Yeah,
I don't, can you direct me to where you're looking?
page 2, line 9. Where it says a person shall not be subject to civil arrest while traveling to, entering, remaining at, or returning from A, and then it lists the spaces.
Yeah, I don't understand the language of the bill here to speak to whether someone is a citizen or resident of Vermont itself. It doesn't seem to speak to that. I thought you were suggesting with respect to Vermont's police power and its understanding of its own people. You could see some different definitions, I think.
Yeah, I think both kind of like the overarching, what is the state's people? Yeah. So it might be a bigger question than just this definition.
So
Yeah, I mean, I think it probably won't be pertinent to this piece of legislation specifically, but states have the authority to define their political communities. They have some leeway in doing so. There are obviously federal constraints with respect to exclusion on the part of the states, but states may recognize as state citizens people who would not necessarily follow from federal constitutional protections as such. But I think states can also regulate with respect to their territory and with respect to people in their jurisdiction who may not be state citizens, for example, or even state residents on any kind of definition of that term, because the state has the authority to regulate its territory as well as its people.
I think with the plain language of what's written on 209, page 2, line 9, that definition, the word a person, that generally refers to anybody that is a human being in the jurisdiction of that state. And yeah, and we can hear from that council further. I suppose, yeah.
Well, I think corporations are only people too for purposes of free speech.
Okay. Any other questions to the professor? All right, well, thank you very much, Professor. I appreciate your testimony. It is helpful and enlightening, and yeah, thank you for coming in.
Okay, thank you for having me.
Thank you.
All right, as scheduled. And we have scheduled for an hour from now, confirmation vote of Judge Ouyang. Do we want to, what was that?
When is it scheduled for?
11:45.
Oh, I see.
10:50. So, do you folks want to take a break, or do you just want to do the vote now, have a discussion, take the vote, wrap things up?
I have a question just about process, because it's been a bit since we've done this. Do we historically have the judge present if they want to be for that vote?
No, historically, it has been for the discussion of the vote, the judge has not been
Okay.
here.
I just wanted to make sure that if that is something, like it's been a while,
Yeah.
that we didn't change it without the judge being able to, if we don't do that, I advocate that we just do it and be done for the day.
Yeah. Pretty sure we haven't had them.
I have no idea.
Anybody recall?
Yeah, we haven't had them in the
Yeah.
room for the vote.
Yeah,
Okay.
that's what I thought.
It'd be a little uncomfortable.
So good thing.
Isn't this work just a little uncomfortable?
No, it's all.
Does the same apply to the Supreme Court justices? I think so, yeah.
You don't want them to be angry about our vote and like come at us.
It also kind of could have a chilling effect on our conversation. It's a little, if we want to have a very candid conversation about how we feel, it feels strange to have them sitting there, unable to say anything.
So I just couldn't remember. Valid point.
But you have Judge Ouyang's mention,
I do.
any discussion that folks want to have regarding the judge?
I just thought he was very impressive.
Yeah.
I was also quite impressed.
I was also quite.
Is this what you're, or,
No, I've seen, just going on The JV, obviously, so you actually want to get there.
Actually, I really appreciate. I know he came in here and sort of explained it as a detriment, his sort of different path towards the judiciary, but I actually find that to be an asset, really bringing in a different viewpoint and a different set of life experiences. And it's, as we've tried to tweak some of the language to really open up the judicial door to non-traditional candidates. And I actually hate using that language because what that really means is like not sloppy white people. I really appreciated this in seeing that in some ways it's working. Not to say there's not more movement in that direction that we could make.
Anybody else?
I think, his experience and personality and level-headedness, and I think it'll be a great asset, to the bench to be able to, I think he'll do a fine job of listening to all the arguments that come before him.
I feel much the same as everybody. I won't just rehash all the same points. I'm happy to make a motion, though not favorably.
I would vote that committee vote to confirm Judge Booth.
And I don't know that we have a bill sheet essentially. I just go up to the secretary. Do we have a bill sheet for it? Or, okay, well, yeah, I think that makes sense. And then I'll see. Yeah, that it's issue.
Yeah, see.
And the clerk. All these.
Yes, Senator Ruth,
Yes.
Senator Meadows, yes, Senator Norris,
Yes.
Senator Lopsky,
Yes.
Senator Hashim,
Yes.
5-0-0.
Oh, fantastic. Who would like to report out? Oh, yeah.
I would be very happy to. Please sit on the calendar for that, right?
Yeah.
Excellent.
So if you want to take that to secretary. All right, committee, good job. We did our first thing. All right, thank you, everybody. We can go on here.